Hi, everyone, and welcome. Today we're talking about California's Ban the Box law, officially known as the Fair Chance Act, and what it means for small and medium-sized businesses. If you're a business owner, HR professional, or office manager, understanding this law is crucial. Not only does it help you avoid legal trouble, but it also ensures fair hiring practices for all. So, what is the Fair Chance Act? In California, this law prohibits employers from asking about criminal history before making a conditional job offer. That means you cannot include conviction history questions on applications. You also cannot ask about past convictions during interviews before offering the position. The goal is simple: allow applicants to be evaluated first on their skills and qualifications, not their record. The Fair Chance Act applies to all employers in California with 5 or more employees. This includes private companies, staffing agencies, and labor contractors. There are some exemptions, like certain law enforcement or state-regulated positions requiring early checks. If you're unsure about a specific role, it's a good idea to check with legal counsel. Here's the step-by-step process for compliance to ensure your business stays protected. Step 1. Don't ask about criminal history until after a conditional offer. This applies to all searches. Step 2. After a conditional offer, you may request conviction history and run a background check. Step 3. If concerns arise, conduct an individualized assessment. Consider seriousness, timing, and job duties. Step 4. If you might withdraw the offer, provide written notice and give the applicant a chance to respond. The applicant typically has 5 business days to provide additional context or rehabilitation info. Step 5. Make your final decision and document everything. Keep records of notices and assessments. Maintaining these records is vital in case of any disputes later on down the line. Even with good intentions, employers can make mistakes. Let's look at some common violations. Avoid job postings that say no felons or clean background required. These are early violations. Another mistake is asking about conviction history directly on the initial application form. Don't reject applicants without providing notice or conducting the required individualized assessment. These mistakes can trigger complaints, significant fines, or even formal legal action against your company. California sets the baseline, but some cities like Los Angeles and San Diego have additional rules. It's important to know both state and local requirements to ensure total compliance. Penalties can include civil fines, required corrective actions, and legal claims from applicants. Here are some practical tips to help your business stay compliant with the Fair Chance Act. First, audit your job postings and applications. Remove any criminal history questions. Train your recruiters and hiring managers on when and how to discuss criminal history correctly. Standardize your policies and forms for individualized assessments and written notices. Keep thorough records of all background checks, notices, and any applicant responses. Review your background check vendors to ensure their processes also comply with the law. Finally, stay up to date on any local and state changes to Fair Chance rules. To wrap up, the Fair Chance Act is more than a legal requirement. It's a smart hiring practice. By evaluating skills first, you broaden your talent pool and promote an inclusive workplace. For more HR guidance and compliance updates, visit kphr.com, your partner in HR compliance.